In 1988, Congress passed the National Vaccine Injury Compensation Program. The logic behind this law was the belief that vaccines were so important to public health that holding vaccine manufacturers accountable for any injuries caused by the products was too dangerous. To end this unconstitutional law, Rand Paul has introduced Senate Bill 3853, the End the Vaccine Carveout Act. We'll look at this act next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation Be Free. Glad you could join me today. I've had an issue with the Vaccine Injury Compensation Act since I first learned about it a decade or two ago. There's more to this story, though, and of course, it's going to be a bit controversial, so if you want to follow along, head to the website constitutionstudy.com, find the article, and you can follow all the links I use for all of my sources. I'll talk more about the website and ways you can help support the work that we're doing here at the end of the episode, but for now, let's talk about the End the Vaccine Carveout Act. In 1988, there was a problem. Vaccine manufacturers were swamped by so many lawsuits related to their products that they threatened to stop manufacturing them. Congress was convinced that vaccines were so important to public health that they had to be protected. In response, they passed the National Vaccine Injury Compensation Act. However, there were two very serious problems that Congress apparently didn't bother to consider. The first problem was a question that Congress didn't ask. Why were so many people suing vaccine manufacturers? Sure, some of the lawsuits may have been frivolous, but since many of those suits were settled for the petitioner, doesn't it beg the question why? Were that many people being injured by vaccines? Were the number and size of settlements a serious impact on the manufacturers, enough to put them out of business? And if that many people were injured by the vaccines, was it possible that the problem was in the vaccine, not the lawsuit? Into this problem steps Congress, with more than a little lobbying by the vaccine manufacturers, I'm sure. That's where problem number two raises its ugly head. You see, the Vaccine Injury Compensation Program law includes no person may bring a civil action for damages in an amount greater than $1,000 or in an unspecified amount against a vaccine administrator or manufacturer in a state or federal court for damages arising from vaccine-related injury or death associated with the administration of a vaccine after October 1st, 1988. And no such court may award damages in an amount greater than $1,000 in a civil action for damages for such a vaccine-related injury or death, unless a petition has been filed in accordance with Section 300AA-16 of this title for compensation under the program for such injury or death. This was not the last law passed by Congress to claim immunity for vaccine manufacturers. The Public Readiness and Emergency Preparedness Act, or PrEP Act, was first passed in 2005, then updated in response to COVID-19. In this law we find, in general, subject to other provisions of this section, a covered person shall be immune from suit and liability under federal and state law with respect to all claims for loss caused by, arising out of, relating to, or resulting from the administration to, or the use by an individual of a covered countermeasure if a declaration under subsection B has been issued with respect to such countermeasures. Now, Congress claimed that anyone who had a claim against one of their covered countermeasures was out of luck. Yes, Congress provided a slush fund to buy off anyone injured by one of these vaccines or other covered countermeasures, but that creates its own problem. What's the problem with Congress protecting vaccine manufacturers from lawsuits? Well, to start with, it violates the First Amendment. While most First Amendment issues I review here are not actually violations of the First Amendment, however, the Vaccine Injury Compensation Program does violate the First Amendment, specifically the Petition Clause, which reads, Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. You have a right to petition the government to redress a grievance. The most common way people do it is by suing. Remember, the judicial branch is part of the government. So when you file a suit, you're petitioning the government for a redress of some grievance. When Congress passed this law, they said you could no longer make such a petition. But wait, Paul, it's called the Vaccine Injury Compensation Program. Isn't getting compensation for your injury a redress of your grievance? Not necessarily. Sure, most people want some financial compensation, but is that all? What about covering future medical bills? What about removing a product from the market or just adding a warning label? These are all potential redresses for some injury by a vaccine, but according to Congress, you don't deserve the opportunity to seek such a redress. While we're talking constitutional issues, how about the fact that the Constitution does not authorize Congress to take on the liability of a third party? That makes this a violation of the 10th Amendment as well, though that's not all the constitutional problems with these laws. The constitutional violations of these laws are not limited to the First Amendment. Not only do the National Vaccine Injury Compensation Act and the PrEP Act claim immunity from any suit involved that covered countermeasures, but they both claim that no court, federal or state, would have jurisdiction. Now, Section 7 of the PrEP Act goes on to claim immunity for the Secretary. No court of the United States or of any state shall have subject matter jurisdiction to review, whether by mandamus or otherwise, any action by the Secretary under this subsection. I looked at the PrEP Act, and you know what I didn't find? Any mention of which Secretary was getting immunity. I assume it's the Secretary of Health and Human Services, but the law doesn't actually state that, at least not as far as I found. There's still a constitutional problem with this part of the legislation. Congress has no authority over the jurisdiction of state courts. Under Article 3, Section 1 of the Constitution, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Congress only ordains and establishes Article 3 courts, i.e. federal courts. They do not ordain, nor do they have the power to regulate state courts. And before you claim supremacy clause in order for a law made by Congress to be considered supreme, it must be made pursuant or following the Constitution of the United States. So, strike three when it comes to constitutionality. Enter Rand Paul and his End the Vaccine Carveout Act. In it we find, beginning on the date of enactment of the End the Vaccine Carveout Act and subject to paragraph 4B, irrespective of whether a person has filed a petition for compensation under the program in relation to vaccine-related injury or death, such person may bring a civil action against a vaccine administrator or manufacturer in a state or federal court for damages arising from such injury or death. Now, under this legislation, should it become law, anyone who suffered a vaccine-related injury or death would be able to sue in either state or federal court. Of course, this clause has the same problem with judicial jurisdiction as the existing laws do. In short, it would reverse part of the unconstitutional law, but not all of it. I've brought these issues up to attorneys who deal with these types of suits, but so far I'm not aware of any that have actually brought up the fundamental issue, which to me shows the sad state of our legal system. How else could laws with 3 constitutional violations exist for so long without a major challenge in court? With so many lawyers filing personal injury cases, why hasn't one of them questioned the constitutionality of either the National Vaccine Injury Compensation Program or the Public Readiness and Emergency Preparedness Act? Could it be because the actual language of the Constitution is not taught in America, not even in our law schools? How can someone get a degree in American law without studying the supreme law of the land? The problem with removing liability for any manufacturer is it also removes the most powerful incentive for them to ensure the safety of their product. Would it surprise you that according to a chart from the Informed Consent Action Network, none of the vaccines on the CDC's childhood vaccination schedule have had a long-term placebo-controlled test before being added? While these vaccines may be safe for the majority of people, how do we know who may be injured if the government agencies that claim to be protecting public health don't demand proper safety studies? Why would a manufacturer who's already investing millions, if not billions, into a product spend even more money to help ensure the safe use of their product if there's no risk of them being sued? Could the explosion of vaccines being added to the childhood vaccination schedule be explained, at least in part, by the fact that vaccine manufacturers can crank out new products without worrying about their safety? I wish Senator Paul well with his proposed legislation. It would be a great step to restoring accountability to the vaccine aspects of our public health system. Now, perhaps if vaccine manufacturers were held accountable for the dangers of their products, they would spend more time testing if they were actually safe. It's been almost 40 years since the Vaccine Injury Compensation Program was created by Congress. It's been over 20 years since the PrEP Act was created. both of the blatantly unconstitutional laws, or laws that contain blatantly unconstitutional sections, have not been challenged in court. And I find that aggravating. I find that an abomination to the law, because a very fundamental question of every law is it constitutional? But yet nobody seems to question the constitutionality of the acts of Congress, even though it's really rather obvious, the unconstitutionality. Why is that? Has our judicial system become so dependent on writs and orders and a lack of understanding of basic law to be blind to its facts? Have they become so dependent on the opinion of other judges that no one even considers questioning the constitutionality of an act by Congress? That scares me, and I hope it scares you too. I hope it scares you enough to learn more and maybe encourage some more action by your legislators, or maybe by attorneys that you know of, or people that have been injured by COVID and other vaccines. See, it's up to us to remind our elected leaders, or at least elected representatives, that they work for us, and to remind courts that they take an oath to support the Constitution, not their previous decisions. We need to bring this up because people have been injured, people have died, and people have been denied their rights without due process of law because of these fake laws. Void, null and void. And again, not my words, ladies and gentlemen. Alexander Hamilton in Federal 78, even the Supreme Court, in the cases Marbury versus Madison, Ex parte Siebold, and Norton v. Shelby County, have all stated that unconstitutional laws are void. When's someone going to take a look at these two? Now, if you want to find out more, if you want to follow up, of course, go to the website, constitutionstudy.com, check out the article, check my sources, double check. I want you to. I want you to be informed so that when you go and you speak to people about this, it's not, well, Paul said. I want you to be able to go to the actual source, the horse's mouth, so to say, not the other end. Now, you can find out more there. You can also support the work that we're doing here. Go to the store and you can buy books. We have mugs and T-shirts, or just donate to the cause. Nobody here gets a salary. Nobody here gets paid. We volunteer, and we pay a lot of money to put this on, and you can help. Again, go to constitutionstudy.com/shop, pick up a book, pick up a mug, or just donate to the cause and help support the work that we're doing here. You can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, and we joined with them for one simple reason. They take a portion of every dollar to support organizations that are defending your rights. That now includes the Constitution Study. That means when you go to patriotmobile.com/constitution and you find a plan that works for you, every time you pay your cell phone bill, you're helping to support the work that we're doing here. Best of all, when you go to patriotmobile.com/constitution, not only can you find a plan that works for you, see if you're eligible for a discount. Everyone from veterans and first responders to families with multiple lines can get a discount. And when you check out, use that code Constitution and you'll get your new line activated absolutely free. So support the Constitution Study and your own rights with your cell phone by going to patriotmobile.com/constitution, finding a plan and discount that works for you. And don't forget to use that code Constitution at checkout to get your new line activated absolutely free. Now, I also hope you'll come back and join us and, hey, maybe bring a friend or two the next time we get together for the Constitution Study.